Hello, this is Matt on the Moon Lambeau channel. The SEC may have ruined their very own case before it even got going simply by overcharging. There are a lot of implications for this, and I've got a thread from attorney John Deaton, who is a member of the XRP community. He is the attorney that is seeking to intervene in the SEC versus Ripple case. And so what's at the core of this is this idea that for whatever reasons, whether it's bad intentions or just bad lawyering, the SEC overcharged specifically by bringing charges against Ripple CEO Brad Garlinghouse and Chris Larsen, who is a co-founder of Ripple, because the burdens of proof, basically, that they did act in the way that the SEC is claiming that they did, the burdens to prove that are quite high, and also bring evidence in to the discovery process that otherwise wouldn't be admissible. And so the SEC may have absolutely ruined their own case before it's even gotten going here, which I wouldn't mind. Not that I want to sacrifice other people for the good of XRP. That's not what I'm saying. But still, it's if that's the case, then it would be good that that Brad and Chris got charged. Not that I want them to, not that they should have been charged. I don't think they should have been charged. I'm just saying a consequence of this for the SEC is that it could be good for XRP. So how about that? But I do want to be clear at the outset here that I don't have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who makes YouTube videos as a fun hobby about Ripple and XRP and crypto. And that's all that's going on here, damn it. And I want to encourage you to follow John Deaton on Twitter if you're not yet doing so, because I love propping up those in the XRP community that are contributing in meaningful ways. And Mr. Deaton, most certainly is. I always value getting his perspective and using my platform to share his thoughts and perspective on what's going on here. And so on Twitter, he's at his first name, John, John, middle initial, the letter E, last name Deaton, Deaton, and then the number 1. And so here's what he wrote. Months ago, I tweeted that the most important decision a prosecutor makes is at the beginning of a case when he decides what charges to file. I predicted that the decision to charge Brad Garlinghouse and Chris Larsen with aiding and abetting would come back to haunt the SEC. Oh, by the way, if I could pause here too, I love that he is not afraid to tag the SEC in these threads. He's constantly tagging the SEC. I love it. Anyway. Then he writes, the SEC charged the 2 executives with reckless conduct for the entirety of their tenures working at Ripple. What that means is that the SEC must prove that Brad and Chris actually believed XRP was a security, or it was reckless for them not to realize XRP was a security. When determining recklessness, the court looks to what an objective person would believe under the circumstances. What Ripple is arguing here is that if at any point during the last 8 years the SEC failed to classify XRP as a security in connection with their own policies, then surely Garlinghouse and Larsen could not have been reckless in believing that XRP was not a security. And so let me just pause right there. To me, truer words have never been spoken. How the hell could it be the case that Brad Garlinghouse and Chris Larsen and everyone else at Ripple should have known? How should they have known that XRP was a security when the SEC had not stated that? And for the better part of a decade to let things proceed, having at some points weekly conversations with Ripple about what they had been doing, but they should have magically known that what they were doing was illegal? No. That does not pass the smell test. That does not make logical sense, and that's why I'm disgusted by these charges that have been brought against Ripple and the 2 executives. And then John continues here. Ironically, 11 months before the lawsuit, I love this, check this out. 11 months before the lawsuit, the investment company Ballard informed the SEC that it would allow its employees and affiliates to only trade the 3 cryptocurrencies not considered securities by the SEC. And what are those? Bitcoin, Ethereum, and, drumroll, XRP. Well, how about that? And so this was shared by a community member, Mickey B. Fresh, on April 12th of this year. Now, admittedly, I was not familiar with, or if I knew at some point, then I just didn't retain the information, not familiar with Ballard Inc. But here you can see, here's the official document. Cryptocurrencies. Check this out from Ballard Inc. here. In light of the extremely complex nature of the legal analysis regarding cryptocurrencies to determine which ones are securities and which ones are not, Ballard has decided to allow investments in 3 cryptocurrencies, Bitcoin, Ethereum, and XRP, that are generally accepted to be currencies and are not currently subject to regulation by the SEC. And so how about that? And I have to admit to you, I had additional confidence investing in XRP the more time passed, because the SEC, by not acting until they finally did, it was certainly at a minimum a tacit implication that, of course, XRP wasn't a security. It's been around the better part of a decade. Why would they not have it? Because they were going against ICOs before they went after Ripple. So like none of it made any damn sense. And so this entity here, Ballard Inc., they felt the same. And they weren't the only ones, though. And this is why Ripple's fair notice defense has such teeth. There were cryptocurrency exchanges, at least one in the United States, if memory serves, who actually approached the SEC to get clarity surrounding XRP, just to be careful. And then I don't know specifically what the conversation was between the SEC and the cryptocurrency exchange in question. But ultimately, the decision that was made by the exchange was to allow the trading of XRP. Now, do you think that they would have done that if it were clear that XRP were a security? Would Ballard here, if they had received fair notice, as the SEC is claiming they offered, do you think that Ballard would have said what they said here about Bitcoin, Ethereum, and XRP not being considered securities? Or would a reasonable, objective person look at the state of things and say, well, yeah, of course the SEC isn't coming after XRP? And you dig in further, where are they going after ICOs? Well, there never was an XRP ICO. Like, you could go on and on and on, and none of it makes a lick of sense. But that's why you go back to, like, what's the motive here? Like, why is the SEC doing what why have they done what they've done? And that's why my best guess, because I don't have anything else, is it's a power grab and or a money grab. That's the best I have. Outside of that, it just doesn't make any sense, right? I mean, okay, fine, you could say there could be some personal something or other that we're just unaware of. This is pure speculation, of course, between people that were or are at the SEC and people at Ripple. So, if that's the case, we'll probably never know. But anyway, John Deaton continues. What if one or more of the SEC commissioners or enforcement lawyers actually owned XRP? Or imagine if one or more of them offered an opinion that XRP could never be considered an investment contract and thus a security under the Howey test. Game over. In the clip contained within my previous thread above, Claytons, that would be former SEC Chair Jay Clayton, arrogantly stated that he preferred to go after the executives because it created a different dynamic in the case. In the video, Grundfest, who is another individual formerly with the SEC, Grundfest stated that it makes the case harder to prove because it requires evidence regarding intent or the state of mind of the executives as opposed to just a strict liability case. But Clayton responded to Grundfest's point by saying it might be worth the trouble. And so think about it, though. So I'll pause here. Why might that have been worth the trouble to go after the executives, even though it's much harder to prove that what they were doing is wrong, especially if you have to improve intent? Why would he do that? Well, because if it does work out for him, and this is just where the arrogance comes into play, because if it does work out, then now you've got precedent set, and now you've got a whole bunch more power, wouldn't you? Freaking asshats, I swear to God. Think about it. If that were to come to pass, what executive... no executive is going to feel like they're in the clear. It's going to heavily sway human behavior moving that way forward, which I think would be unjust because there's not reasonable clarity still. But you know that executives would change the way they're behaving, and they would just give the SEC even more power. So that's why, right? And the arrogance of this guy, it's disgusting here. And then John continues. For the record, I'm not being biased or unfair to the SEC. These are the facts. As a former federal prosecutor, if after a 2.5-year investigation spanning an 8-year period of time, the government can't find any evidence or fraud or misrepresentation, then you generally don't charge the individual executives. So why did the SEC and Clayton choose to do so? Was it to try and allow the government to subpoena all the personal financial records and use it as leverage to force settlement? Was it to interfere with business relations, providing more leverage for settlement? I believe XRP holders should rejoice in the fact that Clayton did what he said he preferred to do. Charge the executives as they did, and then in parentheses he wrote, no offense to Brad and Chris, in parentheses. Without the higher burden of proof, I'm not sure the court orders the Bitcoin and Ethereum documents be produced. There is also a good chance the court wouldn't allow any discovery related to the SEC's internal views on XRP either. So pause, think about that. Because this is huge. The fact that we are going to find out, Ripple's going to find out at least, internally, what documents have been circulated through the SEC, which should provide tremendous insight on their thinking as to what makes or does not make Bitcoin, Ethereum, and XRP a security, each of them individually. Well, if there's tremendous overlap in how they came to conclusions about these, like that can be a problem. And then what if you did see that a bunch of them held or didn't held specific cryptocurrencies? You know, because I mean, the minimum the optics would be poor, you know, but my gosh, what if they have something real at stake to lose, depending on what their own personal holdings are like? To me, all of this is absolutely relevant. Whether or not it's a good legal argument, you know, that I can't speak to because I don't pretend to have a legal background. But just as a layperson, logically thinking through this, to me that matters. And so look, to be clear, I don't think that it was right for Brad and Chris to have been charged. It doesn't make sense. It's abnormal, but still, since it happened, we didn't choose for that to happen. It just did, but it could end up being the best thing for XRP and actually ultimately even Ripple the company. Because with all this information getting out into the wild, my gosh, because Ripple was already transparent. It's the SEC that has stuff that they're hiding in the closet. If anything's going to come out, it's going to come out because it's from the SEC. And now they're being forced to share all of these documents. And without this higher burden of proof, they wouldn't necessarily have to do so. So that's why I was saying at the beginning of the video, the SEC may have ruined their own damn case before it even started here. And I hope that's the case. And then John Deaton writes, it's possible that the court would have allowed all this discovery anyway, based only on the fair notice defense alone, but by charging aiding and abetting, Clayton and crew guaranteed its relevance. XRP holders would have preferred the SEC not claim XRP itself a security and only go after Ripple for specific distributions in early years, whether the decision to charge was because of bad motive or bad lawyering. And so that's something I would get behind. I mean, gosh, if they were just going after Ripple, you know, it's not like I'm beholden to Ripple. They're not paying me. Although if I'll tell you what, I'll take your sweet Ripple money. If you Ripple employees are listening, just give me the sweet Ripple money. I'll take it. But no, seriously, I'm not beholden to Ripple. Not that I want anything bad to happen to them, but I will say that if the SEC had just done what would have been ethically correct and just say, hey, no, we're going after, as John Deaton cited here, specific sales and distribution in the early years, but XRP is now sufficiently decentralized. We're not going after the more recent ones, and XRP itself isn't a security. I think in general, the XRP community would have been okay with that. I would have been okay with that. I think. You know, of course, I'd want to hear Ripple's side to whatever the charges would have been in such a scenario, but maybe that would have made sense perfectly just to get this whole thing done. I mean, I still don't think it's completely fair because the SEC should have acted way sooner, and so I'm not completely convinced that Ripple even then wouldn't have a case, but that would be much more reasonable, and you wouldn't have the entire XRP community pissed off, and you wouldn't have caused multi-billions of dollars of devastation, people over at the SEC, if you would have gone the ethical route. But that's not what you're here to do, is it? I tell you what, you claim your mission here is to protect investors. Well, I'll tell you what, I don't feel very protected by you. Go away. I am not a financial advisor. Should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.